Hi, my name is Jim Malek. I am an attorney practicing law since 1995 with the law firm of Malek Malek. Before I became an attorney, I worked retail with Big Bear, which is no longer with us, but I worked there for 11 years. And as a result of my experience working at Big Bear, I have devoted part of my practice in representing people that have been harmed by hazards in retail stores such as grocery stores and big box stores. So I often get calls from folks that have sustained some type of harm, injury, often as a result of slipping on some hazardous material in the big box store, and they want to know, do I have a case? So the first thing we always look at to determine whether somebody has a case, if they've been injured, is whether or not the hazard that caused the person to fall or be harmed, whether that hazard was what we call open and obvious. The general rule is that a store is not responsible for harms to its customers if the hazardous condition was open and obvious. So what does that mean? Well, first of all, I'll give you a little example, and this can hopefully try to clarify, at least in some folks' minds, what open and obvious is. And before we do that, I usually like to ask people, well, first of all, the definition of open and obvious, is it observable? Was the hazard observable to the customer? And I usually like to ask the person, when you go into a store, or when you're anywhere, obviously you're going to be focused on a specific area in front of you, typically. But does that mean just because you're focused on a specific area that you're not looking all around through your peripheral vision? And I bring that up because a lot of times folks will call me and say, well, I wasn't really paying attention. That's why I didn't see the water on the floor, or I didn't see the substance on the floor. And that is not typically going to get you by the open and obvious defense. But what I usually say to people is, do you walk around with blinders on? No. So when you're walking, are you not looking all around you, maybe focused on one specific area in front of you, but looking all around you through your peripheral vision for hazards, observable hazards? Well, of course I am. And I give you this one example. If you walk into a retail store and there's a brightly colored poisonous snake on the ground, I dare anyone who's watching this video to say that they would not observe that brightly colored poisonous snake. Even if they're not specifically focused on that, your peripheral vision is going to pick up that hazard, and it's going to tell you, hey, don't tread on me, don't step on me. Now, if you had walked into the store and there was a camouflaged snake, a snake that blended in with the flooring, well, you might not see that. And that's kind of what I mean when it's observable. Observable means that you can discern what the hazard is if you're looking at it. And again, that's looking through your peripheral vision and everything. So that brings us to what is one of the greatest causes of slip and falls in a retail establishment. And typically what I find is it's some type of spill, such as water, something typically that's clear. But keep in mind that water, while it can be invisible, like the camouflage snake at times, if you happen to walk in a certain angle and the light gets to reflect off it just right, well, guess what? Now it is the brightly colored poisonous snake. It's something that is observable. So when people slip on water, a lot of times they'll get a call from the insurance company who will want to do an interview before they've retained a lawyer such as Malek Malek. And during that interview, these highly trained adjusters will get the person to say that the hazard was a large puddle of water. They'll tell them the measurements of the puddle, where it was coming from, and that's not really fair. It's not fair because, yes, after you fall and you get the opportunity to move around in the light and get the appropriate reflection and turn that camouflage snake into a brightly colored, I should say venomous snake, it is camouflaged. It is not observable. It is not open and obvious. It's not until you actually fall and get the chance to use the reflections of the light to determine what it was you fell on, the size of the puddle, for instance. And to me, that's just not fair. The insurance adjusters get folks to admit that, and it almost sounds like when they do that this puddle was clearly observable, open and obvious. No store responsibility, no responsibility of the insurance company. You are therefore responsible for all your harms and losses. That's not usually the case. People don't normally intentionally walk into a hazardous condition. So that's kind of the first hurdle you have to get over. The second hurdle in a slip and fall case is a big one, and it requires that folks get the video surveillance typically from the store's cameras, and I can tell you, having done this for a while, that almost every store has cameras all over it. Those cameras aren't necessarily there to protect the patrons. They're there to protect the store from theft, and oftentimes they have a very short, what's called retention period. And what that means is that the video on those cameras gets written over after a short period of time. So it's extremely important that you get a letter out by certified mail to all the appropriate people, loss prevention, anybody that's in charge of video retention, the store itself, to tell them to put a litigation hold or preserve that video evidence. And we usually request the video evidence for at least a couple hours before the fall and a couple hours after the fall. And what does that tell us? Well, like I said, if the store doesn't know about a hazard, how can you expect the store to be responsible for the hazard? They have to have some degree of knowledge. Now, that knowledge can be what we call implied. For instance, if the hazard was on the surface of the floor for a length of period of time, maybe a half hour or more, well, reasonable store owner, there's a good argument, should have been able to detect and warn or clean up that hazardous material. But if you do not request that video surveillance, and you do not have witnesses that say, hey, I saw that there for a period of time, you will not be able to prove notice. And if you don't prove the store knew or should have known about the hazard, you're not going to be able to prove that the store is responsible. So we immediately request video surveillance on any case that we're involved in, usually by overnight delivery, so that we can have the information we need to be able to prove how long that was there. Now, the video may show that the hazard was created just minutes before, in which case it may actually support the store's position. But more often than not, what I find is that you'll see somebody else, another customer, spill the product onto the ground. I've seen it with flower stands where people are constantly picking up the flowers and the water's leaking out all over the floor, and you can see that on the video. You can see that it's been there for quite some time, and then you see that the potential client ends up falling slipping on that material or that water, and you can prove that the store should have known or had notice. I've seen video where I've had employees of the big box store mopping the floor. They don't put up a sign and they walk away. They've created the hazard under those circumstances. But if it didn't have that video, I might not be able to prove that up. So it's extremely important, if you are going to hire a lawyer, that you do so pretty quickly. Again, we're very experienced in these types of cases and would be happy to assist you. I guess the final three thoughts I'd leave with you is, if you are injured as a result of a slip and fall, first thing is seek treatment. Obviously, your health is more important than anything. Get treatment right away. Get whatever care you can right away. That's the most important thing. Number two, don't give a statement to the insurance company. The store's one thing, but the insurance company, I would not give a statement, at least not immediately after the event, because you're going to be talking to somebody that's highly trained and designed to destroy any possibility of getting compensated for your harms and losses. And then three, hire an experienced law firm. At Malek Malek, we've got several attorneys here. We've got the experience. We've got the resources to get you compensated for all your harms and losses if it was caused by store negligence. So I appreciate you taking the time to view this video. Thank you. And from Malek Malek, we really appreciate you, and we certainly appreciate any business that you can give us. Thank you.